Good afternoon, everyone. Welcome to West Virginia University College of Law. Today I am deeply honored to welcome you for the 22nd annual Charles L. Ihlenfeld Lecture, made possible through a generous bequest in Mr. Ihlenfeld's will, in which he established an enduring lecture series focused on ethics and public service, both of which Mr. Ihlenfeld exemplified during his life and through his work. Charles L. Ihlenfeld, the founder of this series, was a prominent West Virginian who practiced law for more than 56 years and devoted himself to ethics and public service, contributing to his community, Wheeling, West Virginia, in many ways, always with the utmost passion and the utmost integrity. His service included local, state, and federal positions, exemplified by his service on the Wheeling City Council as prosecuting attorney for Ohio County and United States Magistrate Judge for the Northern District of West Virginia. Today, we are very fortunate to have with us several distinguished guests. These are 3 generations of the Ihlenfeld family. With us are Mr. Charles Ihlenfeld's son, William, or Bill Ihlenfeld Sr., a 1965 graduate of the College of Law and a person who continues to carry the torch for public service and ethics and exemplifies his father's legacy. His grandson is also with us, Mr. Bill Ihlenfeld II, a 1997 graduate and one of my students of the College of Law, who continues his grandfather's legacy, becoming the U.S. Attorney for the Northern District of West Virginia in 2010, something we're extremely, extremely proud of. His public service is exemplary. He has already established a reputation as a strong, committed, and ethical U.S. Attorney. In addition, we are delighted to have 2 of Mr. Ihlenfeld's great-granddaughters, Sarah Louise and Emma Diane, who took a day off school today to be with us. I'm not sure whether they're happy about that or not. Will the Ihlenfelds please stand so that we may recognize you and your family's generosity? It is now my great pleasure to recognize Charles DeSalvo, the Woodrow A. Potesta Professor of Law at the WVU College of Law, to introduce our speaker, the Honorable Stephanie D. Thacker, Judge, United States Court of Appeals for the 4th Circuit.
It's my great pleasure to introduce our speaker today. If I were to give this introduction based on her resume, I would have plenty of impressive material to work with. She had an outstanding record as a law student. She was a scholarship student. She was an editor of the Law Review. She graduated Coif, and she was a member of the PIA. After graduation, she worked for some very prominent law firms, doing both civil and criminal litigation. She then began to acquire a national reputation through her work for the Department of Justice, first in the U.S. Attorney's Office in Charleston, where she helped mount the first federal domestic violence prosecution in the United States, and then in Washington, where she worked for the Department of Justice's Child Exploitation and Obscenity section. She worked first as a trial attorney in the section, and during her time there, she won the department's Meritorious Award 3 years running. She was then promoted to deputy chief for litigation in the section, a position from which she continued to win awards. The DOJ Special Achievement Award, another Meritorious Award, and then the Attorney General's Distinguished Service Award. She got this because she prosecuted successfully a notorious criminal who had abused numerous children. And then she was promoted again to become the principal chief deputy for the entire section, a position from which she won yet another fistful of awards. With a record like this, it's no wonder that she came to the attention of President Obama, who appointed her to the bench, and she was confirmed by the United States Senate a year ago yesterday, if I'm not mistaken. Well, that's what her resume shows. What her resume does not show is her spirit. For that, you have to see her in action. For that, you have to know her. I was fortunate enough to have Stephanie Thacker as a student when she was a student here, and then I was fortunate enough to work with her as a colleague in our trial advocacy course. And there I saw the spirit of a principled, determined, hard-working woman lawyer who represents all the best West Virginia values, the relentless, powerful, fighting spirit of a West Virginian who has proved to the legal world that alums of this College of Law make not just good public servants, they make outstanding public servants. And so it's my pleasure to introduce to you today an outstanding public servant, a judge of the Fourth Circuit Court of Appeals, Stephanie Thacker.
There's some water under here somewhere. Thank you very much, Dean McConnell and Professor DeSalvo, for, that introduction. I am honored to be here once again at my alma mater, the West Virginia University College of Law. I have to confess, though, that when Dean McConnell first called me a couple weeks ago and asked me if I would come up to the law school to give a talk, I really wasn't quite aware of the significance of what she was asking me to do. And suddenly, I found myself plastered all over note cards and flyers and posters and websites. But, when the dean asks me to do something, I just say, sure. But again, though, I am happy and honored to be here to be a part of the continuing acknowledgement of the great legacy of Charles Ihlenfeld. And I appreciate and am humbled that the Ihlenfeld family has thought of me for this occasion. Today, I plan to talk about my background, my path to the federal bench, my career, and living the codes of conduct across my lifetime and my career, and also hope to have time at the end for question and answer. 25 years ago, about, maybe 26, I sat in this room about where that gentleman is sitting in the third row back, because I was a back seat person for sure, at orientation to law school, wondering what really I was doing here. I know there are a lot of first years here that may have felt the same way on that first day. And frankly, I felt out of place amongst that crowd in this place. But the path to where I stand today in this room, I did not walk alone. And today I want to talk to you all about that path and the key people and places and lessons I learned along the way. I am a native West Virginian, a proud native West Virginian, like Mr. Ihlenfeld, from southern West Virginia, to be exact, Lincoln County in Hamlin, to be more exact, a very small town, a small county, so small we only had one stoplight in the whole county when I was growing up. And I always wondered why it was there. It's in the middle of a curve. We don't really need it. I got it. I don't need the stoplight. And then a few years ago, I opened my hometown paper, the Lincoln Journal, to see that they now agreed with me and the electric bill was too much, and so now it is just a stop sign. So that was our claim to fame, though. We were the snobs of the county because we had the stoplight. So that is the first key place for me along the path to where I stand today, Hamlin, West Virginia. And two extremely key people in my life there, my mother and my grandmother. My twin sister and I and our younger brother were largely raised by those two women in that small town. And I learned a lot of key lessons from them in that place. My grandmother actually ran the bar in Hamlin. A lot to be learned there. And what those two women taught me, or what I saw through them early on, were several things. First of all, they were tough. They had to be. My mother and my parents had my sister and I when they were young. They were teenagers, and they divorced young. My grandmother's father, my grandfather, also passed away fairly young. So she ran that bar in Lincoln County alone. And you might imagine you have to be tough to do that. Secondly, they were hardworking. I said there were a lot of things I learned in the bar. Well, it gave me the opportunity to just observe and listen to people from all walks of life that were there. And in doing so, I learned to keep my own counsel and to keep the confidences of others that were there. From my grandmother and my mother, I also learned to treat others from all walks of life fairly and with respect, and to help others when you can. I saw many times my grandmother doing things for people I didn't recognize or realize how much she did until she passed away. And, of course, then people come out of the woodwork, at her funeral to talk about the many things she did quietly and behind the scenes for people. Young mother who had mentioned at the bar that she was having trouble feeding her family, and then groceries show up on her doorstep from my grandmother. So those were lessons I learned, and learned well in that small town, and that have served me well during the course of my career as a lawyer and now as a judge. In fact, being from a small town was sort of a precursor or a practice for what it's like to be a federal judge, because growing up there, everybody knew who I was and what I was doing all the time. And suddenly, I find that to be the case now. Everybody knows who I am and what I am doing. In small towns, as in most communities, lawyers are seen as leaders and as role models. As well we should be. And it is the reason that each of us who are lawyers, law professors, future lawyers, live by and are expected to live by a code of conduct. It's the reason third years start by taking that ethics exam that I think a few people took a couple weeks ago. And for me, there has been some code of conduct as a common thread throughout my life and my legal career. And as I said, the lessons I learned there in Hamlin, West Virginia, have repeated themselves in those codes of conduct. For example, we see it in the in the rules of professional conduct for lawyers, which I read again in the last week or so. Rule 1.3 counsels us to do our work as lawyers diligently and promptly for our clients. In other words, work hard. Be hard workers, as I learned in that bar in Lincoln County. Rule 1.6, confidentiality, key to our role as lawyers and future lawyers. Keep your own counsel and that of others, of your clients. And so important is fairness that it takes up a number of the rules of professional conduct. 3.4, 4.1, 4.4, and others all speak to fairness, to opposing counsel, opposing parties, third parties, and truthfulness to others, and of course, my new favorite, candor to the court. Another lesson I learned in Hamlin: be fair and respectful to everyone. And importantly today, Rule 6.1 calls upon us as lawyers to commit ourselves when we can to public service. Help others, as was modeled for me early on by my grandmother. In addition to the key people I've mentioned thus far in my life and that key place of Hamlin, West Virginia, there's another key place on my path to the federal bench. This place, where we all sit today, where you all sit as first years. The West Virginia University College of Law was a critical step for me on that path. And one I almost didn't make. It was not something I planned to do, to be a lawyer. I know a lot of people plan to be lawyers from the time they were in kindergarten. That was not me. But my mother planned for me to be a lawyer, right? And it is best to listen to your mother. And I thought it would also, I have a business degree undergrad, I thought it would keep my options open. You never know what the future might bring with a business degree and a law degree. So I made it here to this place, the College of Law. And here I found many other key people on my path. And several are here. And how fitting that one introduced me today. Professor Charles DeSalvo was critical to me in law school. As I said, 25 years ago, I sat back there and felt I didn't know what I was doing here and out of place. But Professor DeSalvo sparked in me a confidence that perhaps I could do this lawyer thing. Maybe it would work out after all. Maybe my mother was right. Public speaking is not my natural state. Not at all. My identical twin sister and I, that I mentioned, we did not talk much to other people until we only talked to each other until we were about 12 or 13. So speaking to others does not come naturally to everyone, but it can be learned. I went to Marshall. They tried to teach me. They required speech class of everyone there. And I waited and waited and waited until the very last opportunity to take it, the very last year, the very last semester with everybody else who does not want to take speech class. I thought we'd all be in it together. And then when we had to give our big speech at the end, which was supposed to be a persuasive speech, I waited till the end. There were like 2 different sessions, and there had been other women in the class. I don't know what happened. By the time I finally got up to give my persuasive speech, I was looking at a room full of men speaking about equal pay for women. So that made it a little more difficult. Not that they weren't, I'm sure, all fair, open-minded men. And then I came to law school, where a number of my professors would say to me, we really think it would help you and others if you would speak up in class, like on my own. Well, that's not going to happen. And then Professor DeSalvo spoke to me after one of his classes, and he probably doesn't even remember, but I do. And he acknowledged for me that it was okay, that I am still in that learning and observing phase. That learning and observing phase that I had begun in that bar in Hamlin. And he validated that for me and assured me that I did have some of the sort of fundamental building blocks to be a lawyer, and that one day I would, he assured me, actually put them all together and speak. And here I am today speaking. So thank you, Professor DeSalvo. This law school and Professor DeSalvo also crystallized for me the public service component of the rules of professional conduct. He mentioned I was a member of the Public Interest Advocates. What he didn't mention is it actually began. It was in its infancy when I was in law school here. So from that small sort of kernel of an idea, the Public Interest Advocates, look how it has grown today, and the impact that this law school and the Public Interest Advocates has made on the legal community and on law students. This law school is the top 15 ranked law school in the country for public interest, and because of that and the clinical programs here. It is to me commended for that. And in my new role as a judge, when I hire law clerks or look to hire law clerks, it is one of the things that I look for on a resume. First of all, I look for some connection to West Virginia and this law school. But I also look for, because they're all going to be, smart, great, accomplished students, I also look for some commitment to public service in some way, either the Public Interest Advocates or a prosecutor's office, a goal to be a public defender, legal aid society, or some volunteerism in their background. It is important to me as a judge, and it was crucial to me, to my professional development and to my path to the federal bench, that I engage in public service. I was a federal prosecutor for 12 years. It was an invaluable opportunity for me. But that was also a step that I did not take alone and would not have taken, I don't think, necessarily of my own accord. It was due to another key person in my career path who pushed me and suggested that I should go and try to become a federal prosecutor. He thought it would be good for me to continue to develop my trial skills. And that other key person in my path to the federal bench was the managing partner at the law firm I worked at the time, Robert B. King, now Judge Robert King, and my colleague on the Fourth Circuit Court of Appeals. So I listened to him, and at his encouragement, I went to the U.S. Attorney's Office in the Southern District of West Virginia, and I am grateful as well to Rebecca Betts, who was then U.S. Attorney, for hiring me. I was in the criminal division there in Charleston for 5 years, where I got to prosecute a number of cases, including, as Professor DeSalvo mentioned, as part of the trial team in the first Violence Against Women Act prosecution in the country. The victim in that case was a woman named Sonia Bailey. She was another key person that impacted me and my career path. As a result of the beating she sustained at the hands of her husband, Sonia remained in a vegetative state from November 1994 until she passed away in December of 2010. She was 49 at the time she passed away. I think about her on a regular basis. And I say she was a key person in my career path because she too sparked something in me to try to raise awareness and to do more about domestic violence. In public service, my public service at the prosecutor's office allowed me to do that. I was able there to work with state, local, and federal agencies to develop more of a protocol and an interaction amongst us all to combat a common problem and to increase awareness and prosecutions. And I had the opportunity to prosecute a number of such cases while I was in the Southern District, and also to argue in the Fourth Circuit Court of Appeals before judges that I now sit on the bench with. So everything on those paths comes full circle. At the U.S. Attorney's Office, I also had the opportunity to work with state, local, and federal agencies to do a similar thing in focusing on coal mine safety prosecutions and federal child support prosecutions, three things that I think are important to the state of West Virginia. I was there for 5 years and then determined to further develop my skill sets. And I went to the Department of Justice Child Exploitation Section in Washington, D.C. There we did three things. I had the opportunity to prosecute, to develop policy and legislation with Congress, and to conduct training for other law enforcement and prosecutors around the country and around the world on how to prosecute child exploitation cases. From Hamlin to this law school to D.C., my law degree allowed me to travel around the world and around the country and to work with and meet people from all over the country. I had the opportunity to work with Attorney General Reno, Attorney General Ashcroft, and Attorney General Gonzalez. One of the things that I think, having those opportunities to work with a number of different people and administrations is one of the things that I also think helped me on my career path. And that public service also gave me the opportunity to make a nationwide impact. What we did in West Virginia, we could do on a larger scale in Washington. One example was the Innocence Lost project. In 2003, there was a lot of media attention and focus drawn to the problem of child prostitution in this country. So similar to what we had been able to do in West Virginia on the domestic violence front, I was able to work with the FBI and the National Center for Missing and Exploited Children to put together a program to target this problem. And it was and is called the Innocence Lost Initiative. Our goal was threefold. We put together training, we put together task forces, and prosecutions. Our goals were prosecution and to rescue child victims, and we began to see results. I left in 2006 to come home, but that initiative still progresses today. Today, there are 47 task forces around the country. There have been 1,017 convictions as a result of that initiative, and thus far, 2,200 child victims recovered. The code of conduct definitely played a role for me as a prosecutor. In fact, perhaps more focused on it, at least certainly more focused on a couple of the rules of conduct. First of all, 3.6, trial publicity. As U.S. Attorney Ihlenfeld well knows, prosecutors have a special duty not to speak in public about anything that is not of public record, anything about any possible testimony, possible plea, the criminal record of the accused, nothing that will prejudice or could potentially prejudice the accused, and for good reason. The foundation upon which our system is established is that everyone is innocent until proven guilty, and prosecutors have a powerful and awesome responsibility in that regard. And Rule 3.8 acknowledges that special responsibility of prosecutors, and one that any future prosecutors in the audience should be mindful of. And one that was driven home for me, again, by now Judge Robert B. King, former United States Attorney Bob King, who underscored for me when he sent me off to be a federal prosecutor the important responsibility to make sure you get it right. And he highlighted it for me and asked me to read the United States Supreme Court case, United States versus Berger, which I bet that U.S. Attorney Ihlenfeld has in his office somewhere. It's a 1935 case in which Justice Sutherland wrote, "The United States Attorney is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he or she is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape, nor innocence suffer." And thanks to Judge King and to Rebecca Betts for giving me that opportunity, that is the code of conduct I lived under as a prosecutor. I did that for 12 years, 7 of those in Washington, D.C. And then, as most of us do, I returned home in 2006 to the wild, wonderful state of West Virginia. Was in private practice for a number of years, doing civil defense and criminal defense, including some pro bono work. And I was very happy in the law and with my law partners. I was, as the song goes, with my friends among the West Virginia hills. And then came the phone call. I was sitting in my office late on a Friday afternoon, you know, one foot to happy hour. In May of 2011, when I got a call asking if the senators, Senator Rockefeller and Senator Manchin, could put me on a list of people to consider, that the White House could consider nominating to the Fourth Circuit. And I said, I don't know. Well, we need to know right away. said, well, I have not. You've clearly been thinking about this. I have not. I need to take 24 hours to think about it. And I did. I took the entire 24 hours and called it, I think it was like 3:30 on Saturday, the next day. And during that 24 hours, I ultimately thought, what could it hurt to keep my options open? My same sort of thinking in going to law school, keep my options open. And also, I thought about my grandmother, who had passed away a number of years ago, and that it is what my grandmother would want me to do. So I said, okay. And a few days later, the senators did recommend me on a list to the White House. And a couple months later, the White House decided that I was the person that they would vet. Vetting is worth another drink of water, for sure. The vetting process was about 2 months long, and that was an expedited process, actually. I understand it usually takes longer. And it involved everything I had ever done. Background checks by the American Bar Association, the FBI, the Department of Justice, the White House. And that meant I interviewed with all of those people and then other people. It also meant that they conducted checks on everywhere I had ever lived, everything I had ever done, everyone I ever knew or thought I knew, everything I had ever written. I'm sure a number of you all were called. I see some heads nodding by those vetters, so thank you. And as I mentioned, everything I had ever written. Thankfully, I have never been on Facebook. Key to my path, I think, to the federal bench. And in September 2011, the President nominated me to serve on the Fourth Circuit Court of Appeals. And I think it was at that point I really did start to begin to feel living the code of judicial conduct, even though I was not yet a judge. Was really on my best behavior. My husband had me on lockdown for, still does, actually. I don't know what I'm saying about that. Still does. But the next step, of course, was the Senate. Because, as we all know, the President's nominations are with the advice and consent of the Senate. So I had to fill out a long Senate questionnaire, which that Senate questionnaire actually underscores the importance of public service, because one of the many questions is that you need to outline your public service and your pro bono work. My Judiciary Committee hearing was in October of 2011, which is all a blur to me now. All I do remember is that one of the things they asked me about was about my law review article that I had written 22 years before. Thankfully, I was the one person who read it, so I was prepared. I was voted out of the committee in November of 2011, and then 1 year ago today, I received my commission from the President, the Senate having confirmed me April 16th, to serve on the Fourth Circuit Court of Appeals. And I am happy, and it is fitting, I think, that I should be here with you all in this place on this anniversary where it all began. And I was sworn in April 20th, 2012. I am now then living the Code of Judicial Conduct. And what does that mean? Many of the same things that the code for lawyers and for prosecutors means. Avoiding the appearance of impropriety, working hard, diligently, fairly, impartially, and now impartially and independently. Two primary changes I guess I've seen in that transition in terms of the code of conduct is I am more isolated now. And I have to work harder, I think, now to develop and maintain friendships and contact with the outside world. Those partners who were my friends among the West Virginia Hills, I've actually just put on a permanent conflict list so I can go out and talk to them freely and be friends with them still. The other thing, though, which is a bigger change, is that I no longer do have or should have public views on issues or opinions or politics or the news of the day. And that really actually began to settle in for me about a month into the job when I was out with friends and others were there socializing. And I forget what was on the news that day. Certainly, if I do remember, I can't tell you. And someone in the group, they were all sharing their opinions, and then somebody looked at me and asked, "What do you think?" And I said, and I started to speak, and then I paused, and I said, "Oh, actually, I think nothing anymore. I am no longer permitted to have opinions unless they are written down and published in a law book somewhere for everyone to read." So needless to say, the last couple of years has been a whirlwind for me, and much has changed in my life over the last couple years and over the last 23 years since I graduated from this institution. But I have to say, the decision to listen to my mother, as most decisions to listen to your mother are, was a good one. And so I am grateful to my mother. I am grateful to my grandmother. I am grateful to this law school and to all my mentors along the way, my path to the federal bench. And I want to close with a quote that I think for me sums up my life and my career as a lawyer. I still think of myself as a lawyer. And it is one that I first heard and learned 25 years ago in this building with another of my great mentors and special professors, Professor Forrest Bowman. And you probably know what it is. Justice Oliver Wendell Holmes, in 1886, when addressing Harvard undergrads about the profession of law, said, quote, "The law is the calling of thinkers. But to those who believe with me that to know is not less than to feel, I say, and I say no longer with any doubt, that a man or a woman may live greatly in the law." Thank you for inviting me. Questions, we have to take. Mm-hmm.
Despite the caveat that she cannot give any opinions, Judge Thacker has agreed to answer questions. And we have a microphone here set up in the middle, and we would love to have any of you who do have a question to come to the microphone. I can see that some of you are thinking about it, but you're hesitant.
They're observers and listeners. One day they will have questions and voice them.
Are there any questions? Okay.
I have a completely personal question, but
Okay.
that's not that bad.
I'm already married.
Okay. But I'm just curious.
I'm sorry. So what was your name?
My name's Josh.
Josh.
And I'm also a twin, an identical twin. And I was just curious what your twin does. Your relationship with her now.
And it's not surprising that you also are a twin, Josh, and ask that question. I get that question, as I'm sure you do, a lot. My sister and I, though alike in many ways, as I'm sure you and your twin are that there's the concept of side-by-side twins who are completely personalities alike and everything, and then there is the concept of mirror image twins. We look alike, we sound alike, we sort of act alike, but we are opposite. My sister is an early education teacher. She's a director of a preschool in Northern Virginia, so she does very much more important work than what I do, in fact. And I have no children at all, so that sort of goes with the mirror image twins. What does your brother do?
He's an engineer. We're actually mirror twins also.
Uh-huh.
Yeah.
All right. Oh, yes, sir. Oh. Kim. All right. Go ahead.
Hi, my name's Allison Peck. I'm in my 4th year as a professor here, and I was really interested in your comments about how Professor DeSalvo really influenced you and gave you confidence that you could do this lawyer thing, and you mentioned Professor Bowman at the end as well. So as a relatively new professor, I'm particularly interested in any other thoughts you might have to share about how we as faculty members can encourage students, and particularly female students who I think often have not had the same encouragement to speak up and to be vocal prior to coming to law school.
I'm sure as professors, you certainly know better than I already how to impact and influence your students. But I would say that one thing I guess I've learned from my sister and watching her, and now even from the role I've had the opportunity to serve as an adjunct for trial ad. Thank you, Justice Starcher and Professor DeSalvo, for that. Is, each individual is an individual. And I think each student is probably best reached on their own terms. There are students that I've certainly seen when I was adjuncting trial ad, where, I could talk to them in the class and engage with them about whatever the topic was, and then others who were sort of hanging back and perhaps more like me, the way that I was in law school. And so I try to approach them in a different way and outside of the group context. But all my professors were fabulous. And now did you actually have a question, sir? I'm sorry. Go ahead. I'm sure I can hear you. And what was your name? And so Jared wants to know what it is that I do all day. I think that's what I got. There are the Fourth Circuit Court of Appeals is actually at full capacity for the first time in the history of the court. We have 15 judges that cover West Virginia, Virginia, North Carolina, South Carolina, and Maryland. And between September and May, we all meet in Richmond about every 5 weeks or so to hear oral arguments. Not all cases, in fact, most cases do not get oral argument. Only about 20% of cases get oral argument. But we decide cases all year long in 3-judge panels. We decide about 5,000 cases a year. from those 5 states. And only about, as I said, 20% of them get oral argument. The rest are decided on briefs. So what I am doing, and my law clerks, I have 4 of them, is reading those reading all the briefs and all the case law, reading the bench memos, and then writing the opinions, voting, and then writing the opinions. So most of the work actually is done back in our home offices. My favorite part is going to Richmond because I get to see everybody and interact at oral argument. But it's a lot of reading and writing because, as you all know, I don't know why briefs are called briefs because they certainly are not. So it's a lot to read. Now you did have a question.
I have a kind of personal question related to career path, too. Several hundred years ago, I clerked for David Souter when he was Deputy Attorney General of New Hampshire. And on my last day he asked me, about my future, and I said, well, I'd really like to take some years off and be a writer. And he looked at me very sternly and said, be careful, the law is not a very forgiving profession. And I remember that, it stayed with me. And I was thinking of our students, actually, because like you, I came to law school not knowing why I was there, except I was crazy. You were obviously saner, but here I am 35 years later, and I'm a law professor, and I find the law is a very forgiving profession. So I was just wondering in terms of, and everything I thought about lawyers back then I no longer think. But I'm just wondering in terms of students, who might aspire. Like, I would love to be a judge, but it's probably too late for me. But although I have hopes. but in terms of students who don't follow the sort of straight and narrow path into the law, do you have any thoughts about how forgiving or unforgiving the legal profession is?
Well, I think we are all actually writers, maybe frustrated writers, readers and writers and thinkers, as Justice Holmes pointed out. And I think the law is relatively forgiving. I mean, there are a number of things you can do with a law degree. My thinking in going to law school that it would keep my options open was accurate. I don't think there's another degree that sort of opens up so many opportunities, varied opportunities, than a law degree. Not everyone has to follow the same path, and I think that's what the great benefit of a law degree is, and it teaches us to read, to write, to think, ultimately to speak, all good things that are going to serve you all well no matter what you decide to do in the future.
Thanks for coming.
Thank you.
You've described sort of your life and the transition to the Fourth Circuit in a very engaging way, and I guess I have two questions about that. You describe well, sort of the way that things are different, what you have to give up, and I'm wondering, what do you miss the most that you can no longer do as a judge, right? What's the thing that's been hardest to give up? And second, being immersed in that world anew as a new judge, there have got to have been things that were different from the way you thought they would be or that have been surprising to you. And I'm wondering if you could say sort of what has been the most unexpected thing about the job that you've encountered. Or maybe you knew exactly what to expect, but I'm guessing that's not entirely the case.
I did have Judge King's. Yes. Thank you. And the first question, I think, was about what I miss the most or that I can no longer do. I certainly have to be much more circumspect than I am used to being around people and with friends or in public. But the most difficult thing about that I can no longer do is sort of just roll out of bed in my pajamas and go to the grocery store. I can't really do that anymore. It's just a constant thinking about everything like that. What I've learned about the court, a lot of things, and I'm still learning, and I expect to be learning for a lifetime now. That I'll speak first about one of my favorite things about being on the court, and that is this learning process. It is one of the things I loved about being a lawyer, and was that you were always learning about whatever the subject area was of the case. Another fabulous thing about a law degree. And now, as a judge, I will forever be learning. Our cases, those 5,000 cases, run the gamut from, criminal stuff to bankruptcy to copyright to things I never knew about, like there is an ancient Chinese coin collector statute. Who knew? But now, I get to learn about those things. But the other thing I learned about this court, in particular, the Fourth Circuit, as you well know, having clerked on the Fourth Circuit, is known as the most congenial court in the country. And that meant one thing to me from the other side of the bench, and that was, after arguments, the Fourth Circuit judges step down and greet counsel that they have just grilled, but they step down from the bench to greet counsel, and they are congenial in that way. It means, and I learned that it means a whole different thing from the other side of the bench. This really is the most congenial court in the country. They are 14 other judges who each welcomed me with open arms, are very helpful, and one thing that we do on the Fourth Circuit that perhaps I'm learning other circuits don't do, is when we disagree, we do so respectfully, both in person and in our dissents. We disagree respectfully, and I think that's another thing that the Code of Conduct for lawyers and being a part of this law school in this small legal community in West Virginia teaches us is to deal with others in your profession and opposing counsel fairly and respectfully. Sue? Did we have one more question? Okay, thank you.
I was fortunate enough to have you as an adjunct professor in trial ad, and as well as a judge in the Lugar Cup.
You did a great job.
Thank you very much. My question is, with such a long-standing and distinguished career as an attorney, did you ever have an ambition to be a judge or a trial judge prior to getting the call?
I did not. Just like I did not plan to go to law school, never in my wildest dreams did I think or plan or realize I could or would be standing here today as a judge. In fact, when I first got that call late on that Friday afternoon, I knew that I'd heard a number of names that had been talked about, one of which was my friend and law partner, who is fabulous and smart and wonderful and would make a great judge. And for the first 10 minutes of that phone call, I talked about him because I thought they were calling about him. That's how little I expected or thought about this before May of 2011. Thanks.
Join me in thanking Judge Thacker for being with us today. We have a gift for you, Judge Thacker, and we made sure that it did not violate any ethical rules. Thank you all very much for being here for the 22nd Annual Ihlenfeld Lecture. I would like to take this minute to ask you to allow our guests actually to leave the room first and then for you to follow them. And the reason for this is because we'd like to give them an opportunity to get to the reception and to get some food so that they can find a place to sit down and then talk to all of you. So thank you very much. And the Ihlenfelds, thank you so very much for being here today.